Everyone to the Illusion of Consensus podcast. I'm Professor Jay Bhattacharya. I wanted to take the time to just bring you up to speed on a case that involves the First Amendment rights of all Americans, in which I'm a plaintiff. It's called the Missouri versus Biden case, and for reasons I'll explain in just a bit, it's now called the Murthy versus Missouri case. I had the great honor of attending the Supreme Court hearing on a matter pertaining to the case yesterday. And what I saw there, I think, deserves the attention of basically everyone in the country. Lots of people haven't heard about the case, in part because the media has failed to cover the case, and when it has covered the case, it's provided quite a slanted view of it. I wanted to tell people, I think, a bit about the history of the case, just to bring everyone up to speed on what exactly it is, what the stakes are, and where the case is right now. So the case was brought originally by the Missouri and Louisiana Attorney General's offices in August of 2022. The Attorney General's offices, that they were looking at what the Biden administration was doing regarding the uh, the 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 uh, the activities of social media companies. What they saw was that the Biden administration was systematically trying to suppress and censor the speech of Americans at scale. They were particularly concerned with a couple of things. One was the activities of the Biden administration in censoring COVID speech, COVID policy speech. And others, there were other items also on their list, including election integrity and so on, where they saw a pattern of censorship. But because they wanted to make sure that there were plaintiffs involved in the case that were very likely censored, they reached out to me, to Martin Kulldorff, to Aaron Kheriaty, and to Jill Hines, who's a health freedom activist in Louisiana, and asked us to join as plaintiffs in the case. I'll tell you, I was delighted to join the case, in part because I'd been mulling over how to how to get action over a pattern of censorship that I personally saw happen to me. When I wrote the Great Barrington Declaration with Martin Kulldorff and Sunetra Gupta in October 2022, Google suppressed the results in country after country. People would send me emails from all over the world showing me Google search results of the Great Barrington Declaration in their language, and it was always, page 3 or page 7 or whatever with 50 hit pieces above it. Later in March of 2021, when Governor DeSantis invited me to a policy roundtable, and I spoke in front of cameras where he's speaking to him to his policy advisors. A television station in Florida filmed us, and when they put the clip on YouTube, this television station, YouTube took down the post, took down the video, and it was basically of me telling the governor that masking children, there was no good evidence that masking children would have any benefit for COVID. An absolutely true statement. So there was this pattern of social media censorship. Martin Kulldorff, when he put a post up arguing that the considerations for vaccinating children were quite different in COVID versus vaccinating adults. In fact, the case was much, much, much worse for vaccinating children. There was no case for vaccinating children for COVID. That post led to Twitter freezing his account. So there was definitely a pattern of censorship. And the question was, what role did the government play? In the Biden administration, it was that we thought was playing a central role in telling social media companies who and what to censor. So when the Missouri and Louisiana Attorney General's offices contacted me about the case, I jumped at the chance to do it. And the case actually met considerable success in the lower courts. On July 4th, 2023, Judge Terry Doughty, who's a federal district judge seeing the case, he looked at the evidence we developed, which included an extensive evidentiary record, including a very interesting deposition of Tony Fauci, emails from the White House to social media companies, essentially telling the social media companies who and what to censor in very, very forceful terms. And with the background, behind it, basically an implied threat that if you don't obey these censorship demands, we're going to censor you at scale. The Surgeon General issued actually a request for information from the public at large to rat on people who were misinforming the public. Actually, it's funny because Martin and I wrote a letter in response to that with the Indiana Attorney General. We told the Surgeon General that the number one source of misinformation was the government itself. And I'll get into that in just a bit. But the point is that there had been an extensive evidentiary record developed in the case that led the judge in the case, Judge Terry Doughty, on July 4, 2023, to say that the Biden administration was violating American First Amendment rights at scale. His view of the matter was summarized by the concluding statement. He analogized what the Biden administration is doing is just establishing a Orwellian ministry of truth. Those were his words in a federal court ruling. And that to stop that, he ordered the Biden administration to stop contacting social media companies for the purpose of censorship, to stop telling social media companies who and what to censor. Actually, he also had a second part of his injunction, because it turns out that the media censorship, the social media censorship, isn't just simply a matter of the Biden administration telling social media companies and directly contacting them saying, look, you have to censor these people and these ideas. They actually act in another way as well. They use third-party cutouts. They use NGOs and universities, including, I'm sorry to say, my own Stanford University, as a way to launder their censorship activities. So what they do is they fund these third parties through grants, through direct contracts and other means, various entities of the government, including nominally research activities, nominally research organizations like the NSF and the NIH, and these third parties essentially establish relationships with social media companies, and through these relationships, they enter into the trust and safety teams of these social media companies and become conduits for demands for censorship. So essentially what happens then is the government says to Stanford Internet Observatory, look, we're really concerned about these people and these ideas. And then the Stanford Internet Observatory goes and tells social media companies, look, we're concerned about these people and these ideas. And then the internet companies take down the posts or censor the people at scale. They train AI algorithms to identify posts. It's a way of sort of indirectly achieving the censorship objectives of the government without actually directly going to social media companies and telling them to do so. Anyway, so Judge Doughty basically told the Biden administration they could not do either of these two things. They couldn't go directly tell social media companies who and what to censor, with the implied threat of destruction of the company behind it, and they also couldn't employ third parties to accomplish the violation of the First Amendment that they otherwise wouldn't be able to accomplish directly on their own. This was a preliminary injunction. So it's a kind of an extraordinary thing to have a preliminary injunction in a case like this. The preliminary injunction essentially means that it's very likely, although the court hasn't yet completed the trial and the full hearing of the case, it's very likely that we will succeed on the merits, and that the harm that is being done in the meantime is so great that it warrants the court telling the offending party, in this case the Biden administration, to stop censoring people. As he issued this warning on July 4th, 2023, I recommend, if you have a chance to go read it, as far as like court rulings goes, it's quite entertaining. For me, it was just a really meaningful thing to see finally courts starting to understand that the First Amendment was a threat. The Biden administration appealed this almost immediately to the Fifth Circuit Court of Appeals. And when the Fifth Circuit heard the case, they looked over the evidentiary record and they agreed that it was a severe violation of the First Amendment. What the Biden administration was doing was a severe violation of the First Amendment, and they upheld the preliminary injunction. They did limit the order. So instead of allowing, remember, there were two aspects of the preliminary injunction that the Judge Terry Doughty said. One was that the Biden administration couldn't directly coerce and force or social media companies with the implied threat of destruction of the company behind it to tell them who and what to censor. That was upheld. That the appellate court upheld. The second thing, which is that they couldn't go to cutouts, third-party cutouts, the appellate court said this shouldn't be part of the preliminary injunction. So what we have left then is a preliminary injunction saying, look, Biden folks, you are not allowed to go to social media companies and tell them that to take down posts on vaccine injuries and on vaccine inefficacy, mask inefficacy, and so on. It's interesting because in that case in front of the appellate court, my own university weighed in against me, saying basically that the Stanford Internet Observatory's actions were just simply research, not actually activities designed to crush the First Amendment. That they were not acting as government cutouts, although it was simply research plans, which I think was quite disingenuous. In fact, when I think about what research entails, typically the ethics of research involve making sure that the research subjects are not harmed by the research itself. Human subjects review boards have reviewed my research for forever, basically saying, look, you have to tell us, make sure that that what you do as a researcher does not harm the research subjects. If you think about what the Stanford Internet Observatory is doing, which is going to social media companies and highlighting things and people to suppress, to silence, that the subjects of their research activities are the whole purpose of their for that sort of research participation is to harm the subject of the research activities. A huge violation of ethical standards of research. So either it's research and the Stanford Internet Observatory is violating the ethical standards of research, or it's not research, it's activism, essentially hiding a way for the government to censor at scale without looking like it's doing it directly, or both, likely both. I wanted to, before I move on to the Supreme Court, I wanted to make sure that people knew what the government was actually trying to protect through its censorship activities. And I just want to say this bluntly: the government was the number one source of misinformation during the pandemic, and it's not subtle. It has the damage was extensive. Many people are dead today that would have been alive had the government not engaged in this systematic misinformation activities. Just to give a short list of this, from the start of the pandemic, the government overestimated the lethality of COVID, causing generalized panic. The government and suppressed people, including me, to try to sort of counter that misinformation with scientific data showing that the infection fatality rate from the disease was lower than the case fatality rate by orders of magnitude that the government was saying. It's de-emphasized the key aspect, the epidemiological aspect of this pandemic, of this disease, which is its risk stratification. It's older people have 1,000-fold or more higher risk of dying from infection than young people. Certainly at the beginning of the pandemic, that was very, very clear. And yet the government tried to misinform the public into thinking that everyone's equally at risk of being harmed from this from infection. It suppressed the idea of immunity after COVID recovery for reasons that are quite hard to fathom, other than to try to make the public panic, or maybe make a demand, be willing to wait until a vaccination was developed in 2020, and then after the vaccine came, the idea that immunity actually had some benefit. So COVID recovery actually had some benefit in terms of providing immunity later. The government is quite afraid of, because they thought it would reduce the demand for the vaccine. The evidence on masking was clear very, very early on in the pandemic. Certainly before the pandemic started, there was no consensus that masking worked. A dozen high-quality randomized studies on the flu had found that masking did not work to suppress the spread of respiratory viral infections like the flu, and so the government censored people to reinforce the lie that there was good evidence that masks could work to protect people from the disease. When we wrote the Great Barrington Declaration, I've already told you about the censorship activities there. The idea that tens of thousands of doctors and scientists and almost 1 million people, many experts opposed the lockdowns, were in favor of focused protection. Well, that damaged the illusion of consent, the idea that this illusion of consensus that they were in favor of the lockdowns. And so the government censored the Great Barrington Declaration. When the vaccines came out and the evidence started emerging that the vaccines did not stop people from getting or spreading the disease, the government censored people. And when it became very clear that the vaccines did cause injuries in certain classes of people, including especially young men with these myocarditis risks, the government censored that information as well. One of the things that we found in the Biden administration's activities from in the Missouri versus Biden case, we found that the Biden administration was telling Facebook to censor and shut down groups of vaccine injured individuals, vaccine injured patients, even though their stories were true. It didn't matter whether they were truly vaccine injured. All that mattered was the fact that the Biden administration didn't want that information out because they thought it would be bad for the public to know it. And they essentially coerced Facebook to shutting that down. So why do I talk about this? The reason is that in the Supreme Court hearing, a major theme of the government's response, and in fact of the Supreme Court justices, was that the Biden administration and the government needed the ability to censor to protect the public from the harms of misinformation. The irony is amazing, because if the government itself is the primary source of misinformation, the First Amendment protects people against the government by allowing regular people, experts, to counter the government openly and freely. What the government was claiming, and what the Supreme Court seemed to take on as a settled premise, is that the government itself needed the ability to censor because it was so dangerous for the public to hear ideas the government didn't want it to hear. The premise is then that the government is some all-knowing entity that can tell the truth from falsity and has an interest in doing so and informing the public about the truth. When in fact, the exact opposite was the case during the pandemic. The government was wrong on vital item after vital item, leading to school closures, leading to lockdowns, leading to tremendous harm with very little to show for it. The United States, with its policies, has among the worst outcomes for COVID and for other aspects of social life since the start of the pandemic, in part because of the bad policies it followed. And the censorship activities guaranteed that those policies were going to be in place, even as the evidence mounted that they were damaging and useless. Okay, so now I want to turn now to what actually happened yesterday in the Supreme Court. So first, just a bit of background here. The Supreme Court was not hearing the case as a whole. The Supreme Court was hearing whether or not the preliminary injunction issued by the federal judge, Judge Doughty, and then amended by the district court, the appellate court, whether it should hold, whether the Biden administration should be held to not contacting social media companies with the purpose of censoring legal speech. So even if this case we lose, God forbid, in front of the Supreme Court on this case, on the preliminary injunction, the case will still go on. We'll still get to hear, still get to actually do the trial in the lower court, the full trial. The preliminary injunction, there's usually a higher standard you have to meet to have a preliminary injunction in place than just winning the case straight up. As I said, the lower court thought that's quite likely we will win the case. Anyway, so that's the stakes. But the stakes are very high, because if the Supreme Court says that the preliminary injunction is somehow invalid, then in the upcoming year, during the election, if there's other health threats and so on, the administration will claim the full right to censor people again and continue to do so. They may still already be doing that despite the preliminary injunction, which has been stayed at this point. Okay, what were the issues that the Supreme Court considered? The first was a question of standing. Now, what does standing mean? I'm not a lawyer, but it's interesting. I've learned about this. Is that you have to have some plaintiff in the case that actually is harmed. Now, there's other ways that you could establish that for instance, a law could be so obviously unconstitutional that you don't need to have a direct plaintiff. It's always a question of, like, can you find some set of people who were harmed? As I've said already, that I think that I qualify. I mean, I was censored by the activities of the government. But the point I want to make is that the plaintiffs in the case, me, Martin Kulldorff, Aaron Kayati, Jill Hines, and Jim Hoft, and others, we are not really the plaintiffs of the case. The true plaintiffs of the case are the millions of people that the Biden administration's activities censored. Those are the people that were harmed, us included, but a much broader class of people. The activities of the Biden administration, the censorship activities, impinged on nearly everyone in the country. And if you posted anything on Facebook, on Twitter, or then certainly you were subject to the censorship regime. And even if you didn't post, if you were just reading social media, you were subject to it because you were deprived of ideas that you otherwise would have seen. So in a sense, the entire American people have standing to sue. The government told the social media companies not just who to censor, but what ideas to censor, and that deprived the government, the American people, of the right to hear those ideas. So we stand for the American people when we stand in this lawsuit. This is a lawsuit, it really, in effect, brought by all of the American people against the government, which violated its most sacred obligation, which is to respect free speech rights. Okay, so what the Supreme Court considered was the idea of traceability. So the administration, we developed evidence from emails and from depositions of the government contacting social media companies saying, censor these people and these ideas. The question is, can you show that these emails directly censored the named plaintiffs? The Supreme Court is quite concerned that whether it was possible to do that. A couple of the justices expressed skepticism that was possible to be shown from the evidentiary record. The problem with that is that actually there was evidence, including people in the case that are directly named in the case. Jim Hoft is a man who runs something called the Gateway Pundit, who I actually spoke with for a podcast earlier. He was directly censored on his election activities. Jill Hines, who runs this Health Freedom Louisiana, she also was directly censored. And we found evidence like that in the case. So even with that more narrow standard of is the harm directly traceable to the named defendants, we meet that standard. But I want to emphasize, if you just look at it in this narrow way, you're really missing the point. The Supreme Court, I think, is missing the point. If it's not possible for citizens to sue the government when it violates the First Amendment, even if it's not directly traceable to the exact people suing, then the First Amendment has no teeth. The government can violate at scale, just hiding its traces through third parties and never directly naming people, just naming ideas. And then who has a standing to sue if the standard is that you have to trace it to particular individuals? If the government says we don't want these ideas out there, and suppresses some set of ideas, for instance, that lockdowns kill people, that children should be in school, well, the government can just do that without naming any individual espousing those ideas. And then all of a sudden, the courts can't enforce it because it's not traceable directly to named plaintiffs. It makes no sense. If the First Amendment doesn't have any teeth, you have to allow any American citizen to essentially enforce it by these kinds of lawsuits. Okay. That's the standing issue. So much for that. Let's consider the second issue that the Supreme Court considered yesterday, and that is, does the First Amendment apply at all? In the lower courts, the Biden administration, argued that the First Amendment doesn't actually apply in this situation. Uh, the In court yesterday, the government's Solicitor General, a lawyer who was representing the government, he said in court pretty openly that he said that during an emergency, it may be the case that the First Amendment doesn't apply, that the government has the right to shut down free speech during an emergency such as the COVID pandemic. His reasoning was that the misinformation spread about the vaccine rollout was a unique circumstance, and it was vital that every American be vaccinated, and so that justified silencing people who were saying things critical of the vaccines. In fact, it was really striking to me hear him say that it was justified because there was a hope on the part of the administration that the vaccine would end the pandemic. I'll tell you, like looking at the epidemiological evidence, that hope wasn't justified even very early on. Even at the end of the randomized trials in December of 2020, the trials never checked to see if the vaccine stopped people from getting and spreading COVID. It's checked to see if it stopped you from getting symptomatic disease, but not if you had any infection. You could have infections with very few symptoms, for instance. It didn't check for that, and it certainly didn't check to see if it stopped you from spreading COVID. It only lasted the trials were only 2 months long, so it was not possible to say with any certainty that the vaccine had any capacity of stopping the pandemic. And yet, the government in court yesterday said, based on that hope, it was justified in censoring Americans at scale because by censoring people, it would increase the demand for the vaccines. What I just want to say, the obvious point, the First Amendment doesn't allow for a vaccine propaganda exemption. The First Amendment is pretty categorical. The government shall make no law abridging the freedom of speech. There's not any caveat in there that says if there's an emergency, that the First Amendment has the right to do so, that the government has the right to do so. And in fact, I'd go further than that. Sometimes I'll hear people say that the First Amendment rights that it's not that rights should be suspended during an emergency, that the First Amendment is too dangerous to have during emergency. Certainly, that seemed to be the government's position. The problem with that reasoning, as we've seen, is that the First Amendment actually protects people's health during an emergency. By allowing there to be speech that counters government misinformation, you end up in a better situation because then there's some hope of protecting people from the government's actions, the misinformed actions. I think it's striking to hear an American government actually say out loud something that I never thought I would hear, that somehow the free speech rights are optional. I hope the Supreme Court remembers that they're actually a fundamental civil right, that there is no emergency exemption of the First Amendment. No government in the United States should ever have that power to suppress speech simply because it thinks there's an emergency. Even if there actually is an emergency, as there was during COVID, it doesn't justify it because that it is vital for the American people to be able to criticize the government when it's making mistakes, and that's most important during an emergency. In the context of this, there was a really interesting hypothetical put out by Justice Jackson. She seemed very concerned that the government be able to suppress the viral spread of dangerous health misinformation. And here was her hypothetical. She said, look, what if there's a social media craze? A lot of teens basically take to jumping out of windows, and they jump out from taller and taller windows, and they dare other teens to jump out from tall windows. And this is a social media craze. People like watch it online, and they go jump out windows also. That's very, very mechanical kind of view of human behavior, that all we do is we just literally just copy one another on the most destructive of things. So her view was that in this context, the government ought to have the power to go tell social media companies, you better stop putting these posts online. You're killing teens because they're jumping out of windows. There's a couple of things about this. One is is it really the case that censoring these kinds of videos is the best way to deal with it? Why not just tell people, I mean, as if you need to be told that jumping out of windows is a really dangerous thing. Um, and if it's, why not rely on parents to tell their kids not to jump out of windows? There are other means for addressing the jumping out of windows problem if it ever comes into existence, God forbid. But I want to say, like, there's a even beyond the fact that there are other means of addressing this. I want to say that there's a real irony here. During the pandemic, the government closed schools in nearly every state. That harmed children in ways that are deep and abiding. And there's only a few people who might jump out of windows. It harmed every child that was subject to it. In effect, the government told kids to jump out of windows and then censored critics who were telling the government that it's a bad idea to close schools and a bad idea to jump out of windows. The First Amendment in this hypothetical would have protected kids. In reality, it would have protected kids by better allowing the counter movement to the government's closure of schools, which now most people, almost everybody, recognizes was a tremendous mistake. The First Amendment then is essential to the protection of health when it's possible, and it always is, that the government is going to get things wrong. Okay, another matter that the Supreme Court considered was whether the activities of the Biden administration in front of the social media companies was actually coercion, or was it just persuasion? Or were they just going to the social media companies and requesting them to make sure that the Great Barrington Revolution doesn't get hurt because it's dangerous? I would say, like, if you look at the evidentiary record that was developed in the Missouri versus Biden case, it's not possible to come away from that evidentiary record and actually maintain the illusion that there was anything other than coercion. There were profanity-laced tirades from the White House chief of staff or of digital communications, a man named Rob Clarity, essentially is telling the social media companies, no, you really need to censor these people, these ideas, or else. The backdrop of this was President Biden going on TV and telling people that Facebook was killing people by allowing posts misinforming people about the vaccines. But so in the back of the heads of the people receiving these tirades from the White House, from the Surgeon General's office, from the CDC, from the FBI, from the State Department activity, from groups called like CISA, all of these demands came on the back of a tremendous pressure campaign, a political pressure campaign, and on top of that, the political pressure campaign included threats of regulating these social media companies effectively out of existence. The social media companies are basically they're subject to something called Section 230, which makes them have a very special legal status. They are neither publishers, like so for instance a newspaper, nor are they common carriers like telephone companies. But they can't be sued for libel because all they're doing is publishing my tweets, your tweets, people's tweets. And and Mark Zuckerberg, the head of Facebook, has basically said that if Section 230 were to be repealed to prevent that exemption, it would be an extinction level event for his company, because they would face lawsuits all over the place for allowing defamatory posts to be put up. I mean, the problem there then is that when the government approached the social media companies and said, look, you have to censor these people and these ideas, oh my God, if that's the case, that we are subject to Section 230, the Biden administration might actually come after us if we don't obey them. And there are other matters that concern how the government treats social media companies that really are extinction level events. So these communications were not just friendly communications to the social media companies to take these down in some genteel way. There was an implied threat behind them. The appellate court, when it looked at this matter, they made an analogy to Al Capone, who would go to Chicago businesses. The gangster would go to Chicago businesses and say, "Look, that's a really nice business you got there. It'd be a shame if something were to happen to it," with the implied threat that if you didn't bribe him and pay him off, he was going to send his thugs to shoot up the business. That is the evidentiary record. And yet in court, it seemed as if the government were entirely oblivious to that, including some of the justices seemed oblivious to the fact that that this coercion was happening. There was another really on this point. There was a sort of interesting exchange about whether there was an analogy to the government calling up press, calling up a newspaper and saying, "Look, you really shouldn't print that story. You're saying false things." Governments do this all the time. Like the press secretary, that's maybe one of his primary jobs is to call up the media and say, "Look, this what you're publishing isn't right. You shouldn't publish this." And the question is, well, what's different in the case of in the case of social media versus when they just call up the press and do this? I'd say there's a couple of major differences here. One is that that there's an extensive protection of the traditional media by the First Amendment lawsuits that have come back, going back in time forever, right? So the government actually doesn't have a credible way to threaten the existence of a traditional media organization because the First Amendment protects it. The whole point about this case is that the social media companies and the people that post there are not protected by the First Amendment. These threats are credible. The government can bring these social media companies down. We saw them do it during the run up to the 2020 election, where they brought down Parler. So this is not like a hypothetical. This is a reality, and so these were real coercive activities to take down posts. The second difference between the traditional media and the government is Section 230. Under as far as I understand the law, the traditional media companies, when they publish articles, they can be sued for libel. If they say something that's maliciously wrong or they defame people, they can face lawsuits. Section 230 protects social media companies from that. So in a sense, it can't possibly be analogous, right? When the government tells social media companies that they have to take things down, they're essentially facing something that's quite different than when a government calls up an editor in New York Times, says, "Oh, you really shouldn't publish this." I mean, New York Times can just go tell the government to go to hell, and they often do. It's very, very difficult for the social media companies to do that. They do sometimes push back, but it's very difficult for them to do. They're doing it walking on a fine wire. If they fall over the edge, the government can threaten their existence. In a sense, Section 230 makes it so that the social media companies are more like a phone company, right? They're supposed to just publish basically every piece of legal speech, not because they don't have to worry about these lawsuits. So when the government tells them to censor, they are forcing the social media companies to act more like publishers, as if Section 230 didn't exist, and yet we don't have a legal recourse when social media companies publish defamation against us. It's the First Amendment here then would protect both people and the companies themselves. So another point that was brought up in the Supreme Court was whether the social media companies should legally be able to, if this preliminary control, wouldn't the social media companies legally be allowed to put up things like child porn or illegal scams and so forth? And the government wouldn't be able to tell them, well, look, you're putting up fraudulent people, you're putting up child porn, and the companies would willy-nilly do that. That seemed to be the premise. The problem here is with that argument is that it's just not true. There are laws that prevent social media companies from putting those kinds of illegal speech up. those laws are not under consideration in this preliminary injunction. The preliminary injunction doesn't change those laws, doesn't touch those laws, doesn't prohibit the government from going and telling social media companies that to not put that kind of illegal content up. If the social media companies published top secret information, for instance, the government even under the preliminary injunction could very easily go and can still tell social media companies to take down those posts, because that's not legal speech. The preliminary injunction of the lower courts in the Missouri versus Biden case does not touch illegal speech. It only touches legal speech. And so this hypothetical that the government wouldn't be able to go and stop the spread of child porn or spread of top secret information is just not true. There was a striking, again, exchange involving Justice Jackson, where she expressed astonishment that the First Amendment might hinder the activities of government. Well, the First Amendment reads, the Congress shall make no law abridging the freedom of speech. Its very purpose is to restrict and hinder the activities of government when it comes to harming a basic civil right, free speech. The Biden president, the Biden White House, absolutely still has the bully pulpit. There seemed to be a lot of concern by the Supreme Court, some of the Supreme Court justices, that somehow the restriction on going and telling social media companies to take down, my speech is going to somehow also restrict President Biden's ability to go up and give speeches and use what they call the bully pulpit to tell people what he thinks. But of course, there's no restriction at all. The preliminary injunction doesn't stop President Biden from going up and giving whatever bombastic speech he wants. During the pandemic, at one point, he gave a speech where he directly blamed the unvaccinated for the spread of the disease, entirely against the scientific record. And of course, there's nothing in the preliminary injunction that prevents him from doing so. If he wants to go spread misinformation from the bully pulpit, he's more than welcome to do so. The way to solve that is to allow speech to counter him. And of course, that is exactly what is at issue. The government basically says, look, we need the First Amendment should protect us too. But of course, the government doesn't need First Amendment protection. It has the ability. It's the one that enforces the First Amendment or doesn't. And the Biden White House can go and say whatever it would like to the public. What it can't do and shouldn't be allowed to do is prevent people from talking back to them and saying, look, what you just said is wrong. That it's not true that the unvaccinated are like the primary spreaders of disease and death. It's just demonizing the population for nothing. In fact, the vaccinated can and do and have spread the disease. Okay, so I mean, none of those arguments made much sense to me. The case as it stands then is we have a preliminary injunction in front of the Supreme Court, where the Biden administration is essentially saying the First Amendment shouldn't apply during an emergency, it shouldn't apply to us, and we shouldn't be constrained by the First Amendment when in our actions. The Supreme Court then has in front of it a case that is fundamentally at the heart of the American Republic. Are we really a republic that's devoted to the idea of these kinds of basic civil liberties? I mean, I always thought that the First Amendment was there because as the First Amendment, because it's the most important set of rights protected by the American Constitution. That's what's at stake right now. The Supreme Court will rule, I think, sometime by June whether it will uphold or strike down the preliminary injunction that the Missouri versus Biden case made. Before I walked into the room yesterday, I had a very optimistic viewpoint. I just sat down in front of the court, watching the case unfold in front of me, and I had tingles up and down my spine. I've never been to the Supreme Court before. I've never been a plaintiff in a Supreme Court case, as an immigrant, it just felt like a great honor to be there. I just sent tingles up and down my spine just thinking about being part of American history. I left the room somewhat dispirited. The justices seemed much more hostile to the idea of free speech than I thought was possible for American American Supreme Court justices to be, and I don't know what the case, the ultimate outcome of the case will be. My friends tell me that you can't always tell how the case will be decided from the oral arguments. I hope that's true, but where we are now is a tremendously high stakes decision by the Supreme Court. The First Amendment itself, I think, it's crucial for our democracy, and I think it stands in the balance right now. Thanks for listening. This has been Professor Jay Bhattacharya for the In the Illusion of Consensus podcast.